Good afternoon for others. I think we can start. We were waiting for a few people to join the webinar. My name is Pedro Moreira, and my background is in pharmacy and industrial chemistry. I'm also an IP agent in Brazil and a partner in the patent department of Dannemann. I have worked in patent and plant variety protection for about 25 years. It is a pleasure to have the opportunity to share some information with you on plant variety in Brazil, plant variety protection. Thank you very much for your time and your interest in this webinar. I hope you enjoy it. The webinar will be divided into two blocks. In the first one, I will provide some information on the validity enforcement of PVP. In the second block, my colleague Pedro Henrique will discuss patent protection in Brazil for gene editing technologies, elite events, and crop products. Please submit your questions using the chat button, and we will try to answer them at the end of the presentations. I see you. I think you are seeing the whole screen, the entire screen right now. So I'll try to speak about plant variety protection, in particular, validity and enforcement of the PVP rights. I intend to present these topics to you. Why Brazil, the legal and regulatory framework, validity, enforcement, and some statistics. Brazil is one of the largest producers and exporters of commodities such as soybeans, corn, beef, chicken, and coffee. Its leadership in international markets demonstrates the efficiency and competitiveness of Brazilian agribusiness. The country benefits from ideal climatic conditions and a vast amount of arable land. This allows for multiple harvests through the year and a large-scale sustainable agriculture production. The Brazilian agribusiness has been adopting technological innovations such as precision farming, drones, biotechnology, and artificial intelligence to improve productivity and efficiency in the sector. Brazil has made strides in sustainable agricultural practice, including no-till farming, crop rotation, and integration of crops, livestock, and forests, contributing to environmental preservation and carbon emission reduction. The grain production increased by 536%, while the cultivated area expanded by 113%. This increase in productivity is attributed to innovations in agribusiness. Coincidence or not, the current IP law and PVP law were enacted in 1996 and 1997, precisely when the end of about 2 decades of stagnation and the beginning of about 2 decades of growth became apparent. Agribusiness exports grew by 3.6% in September 2024 compared to September 2023, reaching a new record of about $14 billion. The last 12 months showed an increase of 1.8, almost 2%, reaching a total of about $166 billion. 84.6% of total exports are concentrated in the soybean complex, meat, sugar alcohol complex, forest products, including here cellulose, cereals, flowers, and coffee. The highlighted categories showed better results: meat, sugar alcohol complex, forest products, and coffee. The main destinations for Brazilian exports are China, Europe, the USA, Southeast Asia, Saudi Arabia, the United Arab Emirates, and Japan. Brazil is the fourth largest agribusiness producer globally. The Ministry of Agriculture and the Brazilian company Embrapa recently published the study of projections for agribusiness Brazil 2023-2024 to 2033-2034, the next decade. This annual publication aims to forecast the future performance of agriculture, serving as a guide for public policies in the sector and as an indicator for the private sector regarding trends in the implanted area, production, consumption, and exports of major agricultural products. Grain production is expected to increase by 27%, whereas the cultivated area is expected to increase by 15%. The future crops are beans, coffee, soybean, maize, rice, and wheat. The WIPO Global Innovation Index of this year presented this data related to Brazil. The data related to GDP, the population. Our population reached 2,011 million people. We are the 10th largest consumer market in the world, and the first consumer market in Latin America. We are occupying the 5th position in the Global Innovation Index of the WIPO, continuing to lead the Latin American and Caribbean region. We are innovation hub leader in Latin American and Caribbean region. In the last 5 years, Brazil is one of the very few jurisdictions having climbed most in the Global Innovation Index in terms of rank progression. Moody's upgrades Brazil's rating in the end of Q3 of 2024 from BA2 to BA1, and the country is one step away from investment grade. The economic growth in the coming years will remain broad. In this section, I'll try to show you the legal and regulatory framework on plant variety protection. Brazil is a member of the UPOV since May 23, 1999, adopting its 1978 Act. New and essentially derived plant varieties, EDVs, are susceptible of protection in our jurisdiction. Several bills have been proposed to incorporate 1991 UPOV's provisions, but none have been enacted so far. The SNPC, Serviço Nacional de Proteção de Cultivares, is the Brazilian PVP office of the Brazilian Ministry of Agriculture, is the competent governmental authority to analyze and grant PVP rights. The main Brazilian legislation and regulations related to PVP are described here. Although it is not an official legal text, the book Proteção de Cultivares no Brasil, Protection of Plant Varieties in Brazil, published by the Ministry of Agriculture and the Federal University of Viçosa in 2011, is widely regarded by PVP practitioners as a valuable guide for better understanding the PVP law and the PVP office examination process. This is a print screen from the website of the Ministry of Agriculture. Until 2008, all PVP applications had to be drafted on paper, and all corresponding forms and formal legal documents had to be submitted to the PVP office in physical form as well. In 2009, the Ministry of Agriculture launched an electronic filing and management platform called Cultivar Web, digitizing all documents and communications between the PVP office and applicants, and creating a system that allows for the management of applications, official fees, communications, and access to the official file wrapper. This was a significant and highly positive advancement. It is important to highlight this slide. The protection and registration of plant varieties in Brazil are two distinct and separate matters, which are independent of each other. They involve separate applications, purposes, and procedures, and are regulated by different laws and governmental authorities under the Brazilian Ministry of Agriculture. PVP, plant variety protection, pertains to the intellectual property rights of the variety, whereas plant variety registration concerns the commercialization of the variety, including importation, production, and other activities. The PVP certificate grants its holder the exclusive right to commercial reproduction within the Brazilian territory, prohibiting non-authorized third parties during the term of protection from producing, offering for sale, or marketing, propagating material of the protected variety. The production, processing, and commercialization of seeds and seedlings within Brazil are contingent upon the prior commercial registrations of the respective plant variety with the competent authority. The registration of a plant variety in Brazil is regulated by the RNC, Registro Nacional de Cultivares, the Registry Office of the Brazilian Ministry of Agriculture, according to the Brazilian Seeds and Seedlings Law 10,711 and its federal decree 10,586. Protection of the plant variety in Brazil is regulated by the SNPC, the Brazilian PVP office, according to the Brazilian PVP law 9456 and its federal decree 2366. In this next section, I'll talk about validity. Here in Brazil, in order for a variety to be susceptible of protection, the respective instructions for performance of tests of distinctness, uniformity, and stability, the US tests, and table of morphological expression characteristics should be published previously by the PVP office. A listing of species of plant varieties currently available for protection in Brazil can be accessed on the website of the PVP office, and they are primarily divided into 7 categories: agricultural, large crops; forest, forage, fruit, vegetable, oleraceous; ornamental, and medicinal and aromatic. The PVP application, the plant variety protection application, comprises basically three forms. Form 1, the application for protection of the plant variety. Form 2, the descriptive technical report of breeding of a plant variety and DUS tests. And Form 3, the table of characteristics and instructions for performance of the DUS test of the plant species. On the right side of the screen, you can see an example of a certificate of protection, which includes the certificate and application numbers, the names of the applicant and breeder, as well as the origin, species, denomination of the variety, and term of protection. As a consequence of the enactment of the Brazilian Biodiversity Law in 2015, the PVP Office established on October 24, 2016, a new requirement for the prosecution of PVP applications. According to this requirement, the applicant must declare whether the plant variety resulted from access to sample of components of the Brazilian genetic heritage or associated traditional knowledge if accessed from June 13, 2000 onward. This is a very important legal provision of the PVP law, the novelty requirement. The novelty requirement is of utmost importance. A variety is considered novel if it has not been offered for sale in Brazil for more than 12 months prior to the filing date of the corresponding PVP application, and respecting said marketing period in Brazil has not been offered for sale in other countries with the breeder's consent for more than 6 years for trees and vines species, and for more than 4 years for other species. If this time frame is not complied, although it is possible to submit the PVP application, it will receive an official serial number and filing date, but it will then most probably be rejected by the PVP office. Here is the term of protection of PVP certificate. The protection of the variety is valid counted from the date of issuance of the provisional certificate of protection for a period of 15 years, except for vines, fruit trees, forest trees, and ornamental trees, including their rootstock, for which the protection period is 18 years. This slide is a sensitive issue in the PVP law and in Brazil. It describes the exceptions of the right to protection according to Article 10 of the PVP law. Article 10 of the PVP law outlines the exceptions to the rights conferred by the certificate of protection, which can be broadly categorized into seed saving, scientific research, and small producers. In seed saving, the rights conferred by the certificate of protection shall not be considered violated by a person who stores and plants seeds for personal use on their own premises or on premises owned by them, who use or sells as food or raw material the product of their planting, except for reproductive purposes. Another exception is the scientific research for those who use the varieties as a source of variation in genetic breeding or scientific research. And there is also the figure of the small producers and family farmers. Although these exceptions are aligned with international standards, some local producers have been using the seed-saving provisions for reproduction and commercialization of protected varieties without the applicant's approval, in clear violation of the law. In this section, this is the enforcement section. I will show you 4 items. The first one, they are practical examples. The first one, the new database on molecular markers for soybean. The second one, a case study on infringement of a protected apple variety. The third one, a case law on infringement of a protected eucalyptus variety. And the fourth one, a case law on the assessment of PVP rights in view of patent rights. This is a very recent news. On November 7, 2024, the Association CropLife Brazil and the Ministry of Agriculture signed an important technical cooperation agreement on a new database of molecular markers of protected soybean varieties. As you may know, molecular markers are a highly efficient and safe tool for accurately determining the genetic profile of a plant variety. This innovative project aimed at modernizing and streamlining the prosecution of PVP, enhancing the efficiency of variety differentiation, and positioning Brazil in international discussions led by the UPOV regarding the use of DNA-based data in PVP applications. The initiative represents a significant step forward in safeguarding the IP rights of breeders investing in plant genetic improvement programs, ultimately benefiting rural producers. The ability to demonstrate that a new variety is unique and innovative is crucial, and the use of molecular markers helps confirm that the variety is genuinely new and distinct from existing ones, thus fulfilling one of the key criteria for granting protection rights. This is the second item, the case study. This is a case study confidential, but authorized by the applicant, the Italian company Kiko, on infringement of PVP rights of a protected apple variety. The apple tree variety named BRAC. The applicant of protection is Kiko, the Italian company, who filed application in Brazil for protecting the BRAC apple variety on 2000 and received protection on 2001, 1 year of prosecution to obtain protection. The term of protection valid was from February 22 to 2001 to February 21 to 2019, 18 years of protection. On April 2000, the infringer was a local partner of the applicant, with whom a licensing agreement was executed for the production and commercialization of BRAC seedlings and apples on the infringer's farm, located in the city of Vacaria, in the state of Rio Grande do Sul. These pictures, the left in the center and the right side, they were obtained from the infringer's website at that moment. On January 2005, the licensee agreement expired, and the applicant noted that unauthorized production and commercialization of BRAC seedlings and apples were taking place under a different denomination called Fuji Select. On April 2005, the applicant sent both a termination letter and a warning letter to the infringer, emphasizing that any and all use of BRAC, including its denomination and trademark, was strictly and explicitly prohibited. On May 2007, the applicant filed a lawsuit against the infringer in the court of Venice, Italy, but the judge's decision could not be applied to the Brazilian context. On January 2010, the applicant initiated investigations procedures, purchased live samples from the infringer, and began to draft a formal complaint citing PVP rights and regulatory issues. And it was discovered that neither the infringer's variety was registered at the RNC, the registry office, nor its orchards were registered at the RENASEM. This was a very important strategy combining PVP rights and regulatory matters. On October 2010, said formal complaint was submitted to the MAPA. On January 2014, the PVP office required live samples for conducting comparative tests between BRAC and the infringer's apples based on BRAC's descriptors and the results from DNA assays using microsatellite markers. On February 2014, local inspection of the seedlings and orchards by the PVP office took place. On May 2014, the applicant's formal complaint was partially accepted. Regarding PVP rights, we had a positive morphological comparison, but DNA testing was not conducted. So regarding PVP rights, the final results were inconclusive. On the other hand, regarding regulatory issues, the lack of registration of the infringer's variety and the lack of registration of the infringer's orchards were conclusive. Although the morphological comparison was successfully completed and indicated infringement, DNA testing was not conducted by either the applicant or the PVP office. This was due to the lack of technical resource at that time, such as those microsatellite markers, which were prohibitively expensive at that time, as well as the need for a comprehensive library specific to the apple species. The decision issued by the Ministry of Agriculture was to seizure all the available apples and seedlings, to destruct the apple orchards of the infringer, and a fine of 58,000 reais, about $26,000. Following this procedure and decision, the infringer ceased their apple production activities and currently they produce and sell ornamental plants. This is the third point regarding a case law. This is a public case law, but incomplete procedure on infringement of plant variety protection rights of a protected eucalyptus variety between local companies Fibria and Eldorado. It should be noted that in 2019, the Brazilian company Suzano completed the acquisition of Fibria. The name of the eucalyptus variety, the denomination is VT02. The protection was requested in 2007 and granted in the same year, 2007. And the term of protection is still valid from September 25, 2007 to September 25, 2025. 15 years of protection. On the left side is the certificate of protection of this eucalyptus variety. On April 2013, Fibria discovered the possible violation by Eldorado during an internal investigation and market monitoring. The company noted the use of eucalyptus varieties that were genetically very similar to its own, protected by PVP rights in Eldorado's cellulose production. Fibria's investigators collected leaves and branches that were on a municipal road that crosses one of Eldorado's farms. Internal comparisons and tests were conducted by Fibria. And additional tests was requested to an impartial and renowned third-party laboratory called Hereditas, which results determined that there was a 99.9999% probability that 5 of the 6 samples of the eucalyptus variety collected from different farms used by Eldorado would be genetically identical to the Fibria's variety. In the same year, Fibria filed an infringement action in the city of Três Lagoas, state of Mato Grosso, containing the claims to stop immediately the use of the variety. The infringer should be prohibited from continuing to use, cultivate, or propagate the variety. Destruction or seizure of the plants and any related materials. There should be a confiscation of or destruction of any materials propagated from the variety, such as clones and seedlings, to prevent any further infringements. Payment of retroactive royalties, compensation for royalties that should have been paid for the unauthorized use of the protected variety during the time the infringer propagated and used it without any license. And any further measures to repair damages beyond the financial damage, additional compensatory measures to repair, mitigate the economic and commercial losses caused by said unauthorized use was also requested. On August 2014, a contestation was submitted. On August 2015, Fibria filed a claim for compensation of 100 million reais, about $26 million. On May 2023, the Superior Court of Justice in Brazil rejected the infringer's contestation, and the judge of the city of Três Lagoas is now free to issue the final ruling. This decision upheld the earlier forensic analysis which showed a genetic match between Eldorado's and Fibria's varieties. With this ruling, the case moved forward to the judge of the city of Três Lagoas, state of Mato Grosso, who is now free to issue the final ruling. No specific deadline has been set for the judge to make this decision. Fibria is required, and it is expected that a decision should be issued for payment of the 100 million reais in damages, or compensation due to the unauthorized use of their variety. Payment of the royalties. Eldorado might be required to pay royalties for the use of the variety during the period when they use it without proper authorization. Stop of using the eucalyptus variety. Eldorado might be prohibited from continuing to use or cultivate the variety in their plantations. Destruction or confiscation of the plant materials. The infringer might be ordered to destroy or surrender any germplant, seedlings, and trees derived from the variety, and other reparatory measures. It is also expected that the court might impose an additional compensatory action to mitigate the commercial impact Fibria faced due to the infringement. This is the fourth and final item regarding enforcement. This is a case law public and also incomplete procedure on assessment of the plant variety rights in view of patent rights. It should be noted that between the rural unions of the state of Rio Grande do Sul versus Monsanto, it should be noted that in 2018, Group Bayer completed the acquisition of Monsanto. In April 2009, the rural unions of the state of Rio Grande do Sul filed a lawsuit against Monsanto, seeking the suspension of royalty charges on transgenic Roundup Ready soybean seeds based on the patent law. The primary allegation of the rural unions is grounded in Article 2 of the PVP law, which they claim would prevent Monsanto from applying the provisions of the patent law to their plant variety seeds and propagation materials. On the other hand, Monsanto states that the patent law covers the DNA and traits contained within the plant materials, while the PVP law provides protection specifically for plant varieties. According to Monsanto, the patent law and the PVP law could be complementary to each other. On October 2019, the Superior Court of Justice issued a mechanism for assumption of jurisdiction for uniform interpretation called in Brazil IAC, or Instrumento de Assunção de Competência, IAC number 4. Said IAC number 4 is favorable to Monsanto's position, and although a rescissory action was filed, it is not expected that the decision of Superior Court is changed. Finally, this is the last section regarding statistics. The table and charts shown in this section are based on data obtained from the Brazilian PVP office on June 2024, and I would like to once again extend my sincere thanks to their collaboration. The table presents qualitative and quantitative data on the total number of PVP filings in Brazil from 2014 to 2023. The chart provides a graphical representation of this data. As you can see, the agricultural category is the most sought after by applicants, followed by ornamental category. The PVP office received an average of about 350 new PVP applications per year, and this average has been increasing since 2022. The table on the left shows the ranking of the top 25 applicants for PVP filings in Brazil from 2014 to 2023. The Brazilian company Embrapa leads the ranking. 7 applicants filed more than 100 applications, and they are responsible for 44% of the total PVP filings in Brazil. The table on the right shows the ranking of the top 15 nationalities of the applicants for PVP filings in Brazil between that period, with Brazil leading the list. It can be observed that the PVP system in Brazil is predominantly used by Brazilian applicants. Here, the table presents qualitative and quantitative data on the total number of PVP grants in Brazil from 2014 to 2023. The chart provides a graphical representation of this data. The agriculture category received the highest number of grant decisions by the PVP office, followed by ornamental category. The PVP office granted an average of about 2015 new PVP certificates per year, and this average has been decreasing since 2022. I'm sorry. The table on the left shows the ranking of the top 25 applicants for PVP grants in Brazil within said period, having the Brazilian company Embrapa leading the ranking. The table on the right shows the ranking of the top 15 nationalities of applicants for grants in Brazil, with Brazil leading the list. In this slide, I'm putting a question for the next months, next years, regarding this increase of filings and decrease of grants and the possible increase of the backlog examination. Currently, average from filing to grants about 1 to 3 years. Thank you very much, and let's listen, Pedro Henrique, please.
Thank you, Pedro. Thank you, everyone who's listening to us. It's a pleasure to be with you and talking about something that is my passion. There is an intersection between agricultural technology and IP. So I hope that you can see my screen. Okay, so talking about patents, as you may know, the general provision of the Brazilian IP law is that any invention that contains the requirements of novelty, inventive step, and this application are patentable. However, there are some relevant eligibility exemptions on the Brazilian IP law and we have some recent developments regarding the PTO's interpretation of these exemptions that are quite relevant for biotechnology involving transgenic plants and gene-edited plants that I will talk a little bit about. So the eligibility exemptions are provided in Articles 10 and 18 of the Brazilian IP law. Article 10 contains exemptions for basically natural things, natural products and processes, and biological processes. So all the exemptions are limited to those that occur in nature. What is relevant is that, unlike in Europe, for instance, I guess you're not yet seeing it. I hope that you can see my screen now. Okay. So, as I was talking about, Article 10. Sorry about that. I hope that you can see now the presentation. Article 10 contains exemptions for naturally occurring products, including living beings and parts, biological material, as well as natural biological process. But the Brazilian IP law also contains another exemption on Article 18 for living beings, except with the exemption of transgenic microorganisms, which are defined in the Article 18 itself. There is a sole paragraph defining these microorganisms, and this definition specifically mentions that it excludes plants and animals. So, in a very brief comparison between the IP law and the TRIPS agreement, which the Brazilian IP law is an internationalization of, we can see that a case could be made that the Brazilian IP law even goes beyond what TRIPS agreement would allow exclusion of, when Article 18 allows the exemption from patentability of parts of living beings, since this is not specifically provided in the TRIPS agreement. Another comparison that's useful to make between the Article 18 and the European Patent Convention is that whereas the European Patent Convention contains an exemption for plant and animal varieties, Article 18 of the Brazilian IP law is broader because it simply mentioned living beings, and these are defined as except microorganisms, so including plants, animals, and any parts thereof, such as cells. There has always been these questions regarding what are the limits of these provisions. Just to sum it up, Article 18 has no limitation to naturally occurring matter, only to living beings in general, including basically plants and animals. Has no limitation to varieties, exclude plant parts, and provides its own definition of what is transgenic. That is not the standard definition by most scientific literature. So this has always been a question for the practitioners in the area, but as examination and even post-grant enforcement actions and nullity actions involving transgenic plants began to occur, the Brazilian PTO had to delve deeper into these provisions. So I will talk a little bit about the development of transgenic plants and how patent applications are filed and prosecuted, whereas these inventions are developed, because this is the main technological field that has provoked the PTO to issue new rules. So very briefly, as many of you may know, transgenic plants are developed usually identifying a gene from other species, usually bacteria, that has some trait of interest. If the gene can be expressed in a plant, this gene is isolated from the bacteria. A lot of work has to go into making this gene useful for expression in a plant, including code optimization. A whole DNA construct has to be developed so that the protein can be correctly expressed in a plant. Promoter sequences have to be developed, and other gene regulatory elements must be present. And obviously, each one of these may be an invention on itself, but as a very general overview, there is usually a first patent application that is filed when the gene is identified. And another patent application is filed when this gene is finally inserted in a commercial plant to be expressed. So when this happens, as you may know, most plant transformation techniques do not allow for direction of where the insert is located in the genome. It involves a lot of trial and error, and many transformation events must be developed and then screened. And so a second patent application is filed for the transgenic event itself, which is usually called elite event because it's screened for the elite features and traits for the transgene. So what's relevant for examination of patent application is that because of the timeline, usually the first patent application is prior art for the second. So in the second patent application, the gene itself, the construct, and the protein expressed are not usually, cannot usually be claimed because they are already parts of the prior art. So very briefly, the claims of the first patent application would be directed to the either recombinant or non-recombinant protein, the polypeptide, the DNA, including the gene, constructs, and so on, the transgenic plants, methods of producing the plants, crossing the plants, and its uses. On the elite event application, the so-called second patent application, most claims are usually directed to the DNA molecule or polynucleotide that is unique because of the unique sequences produced by this insertion into the plant's genome, the transgenic plant comprising this DNA, and also the method of producing, crossing these plants, as well as embodiments related to detection of the transgene and the event in the plants. So the Brazilian PTO has several rules regarding the eligibility exemptions that I mentioned before. First rules were issued on 2002. These were replaced in 2015, and then again the biotech guidelines was published in 2020. This is currently in force and contains some interpretations of what these eligibility exemptions mean for patent examiners. And it's important to bear in mind that whereas the PTO's rules are not law, the examiners are bound to these rules, so they must follow these rules when examining patent applications by the PTO. And finally, the most recent developments have been the issuance of technical notes that have been developed specifically for the assessment of these elite event applications. I will mention more detail moving forward. So just a very brief historical overview. Ever since the Brazilian issued first rules regarding assessment of polynucleotides and polypeptides, they have been deemed chemical compounds. This is the provision of now revoked originally examination guidelines. And because the Article 10 also exempts isolated biological material, the Brazilian PTO interpreted that it's necessary to have a structural difference. The claim must define a structural difference in order to exclude naturally occurring material. It's not enough to be isolated, because this is also exempted from the Brazilian IP law. The most recent rules are generally in line. They have a very similar interpretation. What has been added to this interpretation is that post-filing documents can be used by examiners to show that some claim matter occurs in nature, but it's the examiner's burden to provide these rules. So an objection under Article 10 regarding natural biological material cannot be generally raised without pointing to a document that shows that matter occurs in nature. And also regarding the biological methods, the PTO has provided in its recent rules that since Article 18 does not contain exemptions to processes, then processes involving transgenic plants that do not occur in nature are not covered by any of the eligibility exemptions. So they are patentable. So as long as the resulting plant has a difference in its genetic composition, then there is no eligibility exemption to this matter. to go back to the claims of the first and second patent application that I mentioned, in Brazil, what we have under the PTO's rules is that a protein, if structurally different from naturally occurring protein, is eligible. Same thing for the DNA, construct, gene, and so on. A plant is not eligible because of Article 18, and methods of production, crossing, and using transgenic plants are eligible. When we go to the second patent application, meaning the elite event applications, the main controversy was whether a DNA molecule or polynucleotide comprising parts of the plant genome would be a plant part and thus exempted from patentability. So the many examiners had one point, whereas other examiners had others, and as time went by and several cases were discussed, the PTO was seeing conflicting understandings. However, it was already clear that methods of production of plants, crossing, as well as the embodiments related to detection of the event were eligible, and also that the plant itself was not eligible under Article 18. So the only provision of the PTO's rules regarding what is a plant part were quite general. Basically, that parts include organs, tissues, and cells. It did not go beyond that. And biological materials were also deemed to encompass whole or part, but more explicitly provided that it would go beyond tissues and cells, including extracts, lipids, carbohydrates, DNA, and so on. So there was already some hints that these things are different, but as I mentioned, examiners were still conflicting between each other. There was a different position among several examiners. So as I mentioned, as these patents and applications became important, many corrections were filed, both pre and post-grant oppositions before the PTO were filed. So the PTO felt the need to have more harmonized rules regarding these provisions. So the main question that the PTO faced was basically, to sum it up, what is a plant part? Or put in another way, what are the limits of the eligibility exemption on Article 18? So the first piece of rule that the PTO issued was called Technical Note 1 from 2022, wherein the PTO performed a combined reading of Articles 10 and 18, and noted that since Article 10 contains a provision for even if isolated therefrom, whereas 18 did not contain this provision, then the PTO provided that the term isolated would be enough to overcome the issues regarding Article 18. So they contain this, so they issued this rule without performing a public consultation, requiring that the DNA claims contain this term isolated. So as I mentioned, this was issued without public consultation, and many interest parties were concerned and had several doubts regarding these new rules. So for instance, it was, as I mentioned, isolated in Brazil has a different meaning, for instance, as in Europe, which is usually mean outside of natural context. In Brazil here, isolated would mean outside of the plant or plant cell, which would then mean that the DNA would be patentable as long as outside the plant cell where it performs its function, which it seems to contradict itself. It generated doubts regarding the extent of infringements of some such claims. And also to the extent of if this would be applicable only to elite event or even to anyone, to any DNA claim, because at the end of the day, basically what the PTO was stating is that if the DNA was inserted in the plant or animal genome, it would become part of this organism, and then not be eligible to patentability. So in view of these questions, many associations reached out to the PTO requesting suspension of these technical notes and the issue of a public consultation so that all the users of the system could provide inputs regarding these and many other issues that were raised on these technical notes. So in June 2022, the PTO issued a public consultation providing the users of the system an opportunity to provide comments and arguments regarding all these rules. So two main points, obviously many points were discussed regarding several provisions, but mostly for the matter we are discussing today, main point was an exceptional rule according to the Brazilian legal case law can only be applied narrowly, so it should not be interpreted broadly since it's already an exception. And second, since the PTO itself performed a combined reading between Articles 10 and 18, when we do that, we see that it's not only even if isolated therefrom, there are differences. There are many other differences which show that the Brazilian legislator, when decided to exclude naturally occurring matter, was much broader, using much more language, including biological material, genome, and germplasm, that the Brazilian legislator did not use when drafting Article 18. So there is an intention to exclude natural things in Article 10 that did not exist in Article 18. And as a result of the public consultation, the Brazilian PTO finally issued on May of last year an updated technical note, also called Technical Note 1 of 2023, wherein it basically acknowledges these main points that since it's an exceptional rule, which cannot be broadly interpreted, and also that these matter that Article 18 does not mention, that are mentioned in 10, should be eligible to patentability as long as they are not excluded by Article 10. So if they are not natural, which is what Article 10 is directed to, then Article 18 does not apply. So the main development here is that a plant genome is mentioned in Article 10. So what the PTO is correctly interpreting is that a plant genome that is not natural is eligible to patentability. As well as, for instance, a DNA molecule that is integrated in a plant genome, and so on. So in the technical note itself, the PTO provides examples of subject matter of claim language that is deemed eligible, which is here for you to see. And as a result, we started to, on the last 18 months, we started seeing patents being issued by the PTO with such language. Of course, because of other rules regarding amendments after request for examination, I will briefly talk about them next. Many applications could not redraft their claims during examination, but the ones that had support were granted with claims that already recite either plant chromosome or genomic DNA or plant genome and so on. And what's even more relevant here is that these claims are enforceable against both, against basically any use of commercial use of the plant, including crop products. So as a result, basically, we now have in Brazil, a framework for protection of transgenic plants, not limited here exclusively to elite events, but it's now clear what is eligible in Brazil, what are the limits of the eligibility exemptions, and the plant genome or genomic DNA are the main embodiments to be claimed in these inventions. When we saw that, we also understood that since the provisions of Article 18 are not applicable to non-naturally occurring genomes, then basically it's already providing the PTO's rules a clear guideline to how gene-edited plants can be protected. So the genome of gene-edited plants that is different from those of natural occurrence, and obviously keep in mind that there must be clear evidence according to the PTO's rules that such matter would occur in nature in order to raise an objection regarding a naturally occurring genome. Can now also be protected in view of these rules. So here we have examples of summarized claim sets that we would propose for both applications dealing with transgenic plants or gene-edited plants that are eligible under the PTO's rules. So I'll briefly talk about how to best use this to obtain protection for your inventions in view of a few pitfalls that may be found during examination before the Brazilian PTO. The first one is that under the PTO's rules, the request for examination is basically deemed to be a waiver of unclaimed matter or unclaimed language. So under the PTO rules, if the examination is requested for, let's say, a plant claim, you would not be allowed to redraft to a plant genome under examination. So it's very important to perform voluntary amendments to adapt the claims to the Brazilian practice so that examination is requested for eligible both subject matter and claim language. There are also very strict rules regarding the breadth of the claims, both in terms of claim language and the extrapolation that the PTO allows in view of experimental results contained in the application as filed. And I'll also briefly talk about some rules regarding administrative appeals. So in view, this is the main things to keep in mind to obtain optimal protection for your inventions. So as I mentioned, the request for examinations, first key point to keep in mind, so it's very, very important to make sure that examination is requested within the legal deadline of 36 months from filing for a set of claims that is already adapted to Brazilian practice. When we move to the examination procedure, nowadays, as many of you may know, the PTO has issues. The first action by the PTO is the issue of a preliminary office action, which is an invitation by the PTO for the applicant to submit claim amendments or comments addressing prior art cited against corresponding applications in other jurisdictions. This the PTO does before performing substantive examination. So only based on the response to this preliminary office action, then the examiner will perform substantive examination. Usually you will receive a first office action, and any objection that is not fully overcome in this first office action can already be basis for issuance of a rejection decision. It's possible that a second or even a third office action are issued, but you should not rely on that. So it's very important to address all objections issued on an office action to avoid receiving a rejection decision. However, if a rejection decision is issued, an administrative appeal is still available to bring the application to the PTO's appellate examiners. Under the administrative appeal, the examiners can also issue an office action or final decision. And obviously important to bear in mind that the courts are fully competent to revert any of the PTO's decisions in its entirety. So the relevant rules for administrative appeals is that the scope of the appeal has been narrowed. It used to be the case that the appeal was basically a new office action being issued, and the applicant was allowed to argue whatever way applicant wanted during appeal and amend the claims, as long as limited to the claims on file when the examination was requested. Under these new rules, the appeal is limited to the specific objections contained in the rejection decision. Applicant is no longer allowed to limit the claims based on the specification, basically only limiting independent claims based on dependent claims. And also, if applicant has failed to comply with a requirement by an examiner during examination, then it would not be allowed to afterwards go ahead and comply. So it's very important to keep in mind these when performing examination before the Brazilian PTO. Finally, the division of practice in Brazil is also somewhat unique. The PTO's rules generally treats divisionals as a way to obtain protection to pursue subject matter that is deemed to lack units of invention, but not as a way to have a new round of examination. So a divisional that is filed with claiming the same subject matter may be outright rejected and not be useful for having new opinions and submitting new arguments for pursuing the same subject matter. So even more important to make sure to address all objections, submit auxiliary requests, trying to overcome all objections as a fallback, because applicant may be prevented to do so moving forward. So here is a brief list of do's and don'ts of what to do during prosecution of patent applications in Brazil to make sure that you have optimal protection. As I mentioned, reviewing claims before and adapting to local practice before requesting examination to make sure that they are drafted in a legible claim language. Having experimental evidence to comply with the sufficient disclosure requirements and rules of the PTO. Here, whereas ideally it could be present in the application as filed, it's also possible to submit post-filing data. So if from one side, the examination may take more time in Brazil, you should definitely take this time to produce experimental results showing that the commercial product has the technical effect of the invention, so that any limitations that the examiners require during examination, you can do not exclude the commercial product. And finally, submitting auxiliary requests and dependent claims during examination to avoid losing the rights to further restricting their claims moving forward. And what not to do would be basically requesting examination without complying with the PTO's practice, rely on a single experimental result that is not the commercial product, submitting general response to an offset action without addressing each objection of the examiner, and not submitting auxiliary requests and dependent claims that would fully comply with examiner's requirements. And also rely on divisionals as a new round of examination, which may not be available. Finally, on a different subject, I understand that several inventions dealing with agricultural compositions are also relevant. You should keep in mind that under the PTO's rules, a composition that is defined in a claim as a single comprising a single component is deemed to cover the component itself, and if the component occurs in nature, then an objection under Article 18 would be expected. The PTO's rules even go beyond that and consider that mere dilution of a non-eligible component would still be excluded from patentability. So this makes it very important to have support on the application as filed to limit such claims, adding restrictions such as additional components that are not natural, so as to overcome an objection under Article 10, whereas still covering the commercial product. Another point is that coated seeds are deemed to be compositions. So this means that Article 18 does not apply, so it's not a plant part because it has more than one element, which at least one of these elements is not a plant part, so it's a composition. So basically the composition provisions apply here, not the provisions of Article 18. And if as I mentioned, the active ingredient of a composition is biological, even more important to have support on the application as filed for additional components that would allow a restriction of the claim to exclude the naturally occurring subject matter while still covering the commercial embodiments. So this is the subject matter that I had to share with you today. Thank you so much for attending to this, and Pedro and I are here to answer any questions that you have. Thank you.
Yeah, thank you, Pedro. I think our time is up, but I'll try to answer just a couple of questions. Would applying and receiving RNC registration prior to filing the SNPC, the PVP application, would possibly negatively impact the petition? No. The most sensitive matter here is the date of first commercialization of the plant variety. 18 years, the term of validity of the certificate of protection is counted from the issuance or the filing date. In plant variety is different from patent. The patent you count from the filing date. For plant varieties, you count from the issuance date of the provisional protection. Okay. Are genomic markers examined by the PVP office during examination? I was told by Stefania. Stefania is the head of the PVP office. I was told by Stefania that they do not consider genomic markers during examination. Yes, you are correct. The genomic markers are not considered during examination. The information provided by Stefania is the same that I am aware of. And this last question, what happened to the seized apples in the BRAC case? Were these apples used for social purposes? Unfortunately not. The seized apples were destroyed. The Ministry of Agriculture could not guarantee its phytosanitary conditions. This was a couple of questions. And I'm sorry, maybe Pedro, you want to answer anything else?
Yeah, I can see an event question. Kelly's question is asking whether inventive step rejections in view of prior art, where the trait has been previously expressed. So what the technical notes in force provides is that an event would have to have an unexpected effect. So basically the PTO's position is that, for instance, if the prior art discloses that a certain protein is able to confer herbicide resistance, and the only experimental results, the effect of disclosing an event application is herbicide resistance, then it would lack inventive step because it would be expected. But the unexpected effect can be any. So if the herbicidal resistance is increased in the event from what would be expected from the prior art, then the PTO will request experimental data comparing one with the other to show such effect. Or the effect may even be very different. So it may, although the transgene is for herbicide resistance, the effect may due to several factors, may be with regard to other traits of the plant, so production of protein seeds or yield of the plants and so on. So this can also be an unexpected effect that would provide inventive activity.
Yes, and some people asked about a copy of the presentation and a copy of this webinar. The entire webinar will be available at the institute, the IDS website. And of course, we can send also the presentations, if possible, please, so we can identify who wants the presentation. Please send us an email, then we will be glad to return the presentation. And in the name of the Dannemann Siemsen Institute. I thank you very much for your interest and your time.
Thank you. Nice
Thank
day.
you. Bye-bye.
Bye-bye.